We have held that the modern trend is of pragmatic and not pedantic interpretation. The interpretation leading to absurdity and which renders a provision to be futility has to be avoided. Any interpretation which advances the purpose and object of the legislation has to be preferred when two constructions are possible of particular provision. And applying these principles, we have held that a restrictive meaning cannot be given to word any. And insofar as issue number 2 is concerned, again refer to the Constitution Bench judgments in Hamdard Dawakhana, Harakchand, Ratanchand, Bantiya, and Birla Cotton and Spinning and Weaving Mills. We have held that for finding out the policy and guidance, a resource can be held to various provisions of the Act, including the preamble, the purpose of the Act, and what is necessary is that the parent statute must consist of an essential legislative function, that is determination of legislative policy, and it is permissible in view of the multifarious activities that it is necessary for the legislature to delegate the working of details. When we have considered the status of the RBI, we have referred to the judgment of the Constitution Bench in Joseph Kurila, then the judgment authored by my learned brother Justice Ram Subramanian in Internet College. And we have specifically emphasized on the primary role of the RBI in issuance and regulations of banknotes, then its important role in monetary and economic policy of the country. Then we also considered the nature of body to whom the delegation is made. In the present case, the delegation is made to the central government, which is answerable to Parliament, and Parliaments are in fact answerable to the citizens of the country. In this respect, we have referred to the judgment of the Constitution Bench in Birla Cotton. Then in the case of Harakchand itself, when clause B of subsection 2 of section 5 was held unconstitutional, in the very same judgment, the Constitution Bench has held clause A of subsection 2 of section 5 to be constitutional on the ground that it provided that the administrator can take action after consultation with the RBI, and therefore there was self-imposed provision which required the RBI to be taken into consideration. Applying the same principle, we have held that in the present case also, the central government is required to take the action after recommendation of the central board, and therefore there is an inbuilt safeguard. And so, what the third issue is concerned, we have basically relied on the judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various Constitution Bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Sri Sitaram Sugar Company versus Union. And which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. And we have also scrutinized the record. And after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government over a last period of 6 months. Then, insofar as the fourth issue is concerned, we have considered the 4-pronged test held in modern dental education. One, as to whether the action was designated for a proper purpose. We find that the 3 purposes are proper purposes, and whether there was a reasonable nexus of the measure with the purpose sought to be achieved. And we have held that there was a reasonable nexus. Then, insofar as the third test with regard to alternate measures is concerned, there cannot be any alternate measures for the action which is thought to be done by demonetization. Then the fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights, and applying all these four tests, we have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitution Bench. In the present case, the period provided is 52 days, and therefore applying the principles laid therein, it cannot be said to be an unreasonable period. Then insofar as issue number 6 is concerned, we have held that the entire scheme of section 3 and 4 has to be considered. The powers under the provision of subsection 2 of section 4 cannot be construed in isolation, and therefore the RBI does not have an independent power. Insofar as hardship is concerned, we have referred to the judgment in the case of R.K. Garg and Sonia Bhatia, and we also considered that it is not relevant as to whether the objective achieved has objective thought has been achieved or not. So what is required is that there has to be an objective which is for the proper purposes, and there has to be a reasonable nexus with the measure and the object to be achieved. We also held that we cannot direct the central government to exercise its powers under subsection 2, and it is for the central government to exercise such a power if it finds that the exigency so arise. Accordingly, we have answered the reference as under 1. The power available to the central government under subsection 2 of section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on 2 earlier occasions the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. Then second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation, inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the impugn notification dated 8 November 2016 does not suffer from any flaws in the decision-making process. 4, the impugn notification dated 8 November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5, the period provided for exchange of notes while the impugn notification dated 8 November 2016 cannot be said to be unreasonable. And 6, the RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the Learned Attorney General, Sri P. Chidambaram, Sri Sham Diwan, and Sri Jaideep Gupta, Learned Counsel, and all other counsels appearing for the parties.
Excellency. I've had the benefit of reading the judgment proposed by His Lordship B.R. Gawai Ji. However, I wish to differ on the reasoning and conclusions arrived at in his judgment with regard to exercise of power by the central government in subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impugned notification dated 8th November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gawai J does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the Reserve Bank of India, hereinafter referred to as the Act, as the bank. Hence, if demonetization is to be initiated by the central government, such power is derived from entry 36 of list 1 of the 7th schedule to the Constitution, which speaks of currency, coinage, and legal tender foreign exchange. I've quoted the 7 issues, judgments, which were, the references order dated 16th December 2016, where 9 questions were referred. His Lordship Gawai J has reframed the questions referred to this Constitution bench and culled out 6 questions, which have been answered in the erudite judgment proposed by him. My views on each of such questions, as contrasted with those of His Lordship's, have been expressed in a tabular form hereunder for easy reference. It is at the head, I have put that. Then I have stated about the overview regarding the importance of the Reserve Bank of India and the Reserve Bank of India Act 1934. Then I have spoken about the history and instances of demonetization the world over, in France, in the United States of America, Britain, Congo, Ghana, Nigeria, Myanmar, Russia, Venezuela, Zimbabwe, and the history of demonetization in India in the 2 periods of 1947 and 1978. Then, while speaking about the Reserve Bank of India being the bulwark of the Indian economy, I've quoted Internet and Mobile Association of India versus RBI, wherein one of us, we, Ram Suprapatyam J, while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the bank in the Indian economy. Then I've spoken about the economic and fiscal policies interference by the court and cited the judgments. What emerges from an understanding of the decisions referred to above or the subject of judicial review of economic policy may be culled out as under: 1. That the court is not to sit in judgment over the merits of economic or financial policy. 2. That the scope of interference by a court is limited to instances where the impugned scheme or legislation in the economic arena has been enacted in violation of any constitutional or statutory provisions. 3. That the court may not undertake a foray into the merits, demerits, sufficiency or lack thereof, success in realizing the objectives, etc., of an economic policy, as such an analysis is the prerogative of the government in consultation with experts in the field. Being mindful of the limited scope of judicial review permissible in matters concerning economic policy decisions, I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding in the issuance of the impugned notification was correct or as being contrary to subsection 2 of section 26 of the Act and allied aspects of the case. It may be stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. Then I have analyzed section 26 of the Act interpretation. There I have made again a table with a view to lend perspective to the issue with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. the parameters for distinction. Then second, when the proposal for demonetization originates by way of a recommendation by the central